Let's talk about something that might make you a little uneasy. How your clients could unknowingly sabotage the very confidentiality you've sworn to protect. Yes, we're talking about the increasing reliance on AI tools like ChatGPT or Microsoft Copilot to simplify those dense legal documents or decipher the complexities of legal advice that you're giving your clients. It sounds like a great idea in theory, right? For a client to use these tools to interpret or explain to them what it is you're communicating. But what if I told you that this seemingly harmless act could actually lead to an accidental waiver of attorney-client privilege? Here's the double-edged sword of AI in legal practice that I haven't heard a lot of people talk about. The truth of the matter is artificial intelligence is undeniably transforming the legal landscape. From research assistance to document drafting, AI is making legal work faster, more efficient, and oftentimes more accurate. But there's a catch. These tools aren't lawyers, and they don't understand the nuances of legal confidentiality. When your client uploads a PDF of a legal document to an AI for a quick breakdown, or your client dictates the advice that you gave him or her or they into an AI system to get a more digestible summary, they might be unknowingly waiving attorney-client privilege. All right, let me say that again. They might be waiving attorney-client privilege. So let's break down exactly what this means and why it matters. Look, as we all know, attorney-client privilege is the backbone of the trust that our clients place in us. It ensures that anything our clients share with you, remains confidential, shielded from the prying eyes of opposing counsel or even the court. In a similar fashion, the work product doctrine protects your strategic legal thinking, safeguarding your approach from being exposed. But here's the kicker. These protections aren't bulletproof, especially in today's digital age. The moment a client shares privileged information with a third party, including an AI system, they risk losing these protections. And that's not something you want to deal with in the middle of a high-stakes case. Now, let's make this real. Imagine a client is puzzled by the legal jargon in a contract. Frustrated, they decide to upload the contract into ChatGPT, asking for a plain English translation. Or maybe they use Microsoft Copilot to break down your legal advice into something more understandable. In that instant, they might have inadvertently shared privileged information with a third party, effectively waiving the confidentiality you've worked so hard to maintain. This isn't just a theoretical concern. Courts could interpret such actions as a voluntary waiver of privilege, leaving your client's sensitive information open to discovery. Still, another concern is if the work product doctrine is compromised. The other side might gain insight into your legal strategy. It's like handing the opposing team your playbook just before the big game. So here's the deal. By understanding the risk of AI in this context, you can take proactive steps to protect your clients and, by extension, protect the attorney-client privilege, the attorney work product privilege, and also your reputation. With the above in mind, here are 3 ways that you can turn this potential pitfall into a strength in your practice. Number 1, revamp your engagement letters and retainer agreements. Make it crystal clear from the start. Clients need to understand that sharing confidential information with AI systems can jeopardize their legal protections. Include specific warnings and real-world examples in your engagement letters. This sets the tone and makes them aware that confidentiality isn't just a legal term. It's a crucial part of their case strategy. Number 2, and I mentioned this above, but tighten up your retainer agreements. In addition to just in your engagement letters, in your retainer agreements, add a clause that explicitly warns against sharing privileged communications or work product with AI systems without consulting you first. This isn't just a suggestion. Let them know it's a proactive measure that you can both take to protect your client's best interest. If a waiver is ever claimed, you've got the written documentation to back you up. Here's the third solution: ongoing client education. Don't let the warnings end with the engagement letter or the retainer agreement. On a routine basis, remind your clients of the importance of confidentiality. This can be as simple as including a confidentiality tip in your email signature or sending periodic reminders about the risk of using AI without your guidance. Keeping this top of mind, and this is the critical part, keeping it top of mind and in front of your client ensures that your client won't forget these crucial details when they're knee-deep in legal issues looking for explanations and clarifications with respect to your documents and your communications with them. So here's the takeaway. You want to stay ahead of the curve. Bottom line, AI is here to stay, and its role in the legal world is only going to grow. But with great power comes great responsibility. And as a lawyer, it's up to you to ensure that your clients don't accidentally waive their rights because they don't understand the risk. Educate them, guide them, and do everything you can to help them help you protect the integrity of the attorney-client relationship. All right, that's it for today's episode. If you like what you've heard and you'd like to join our community, you'd like to be a part of this journey that we're taking together, learning about AI, exploring new products and services, new approaches and new mindsets, then please, by all means, join us here on the podcast. Subscribe, like, share. Also, I'd love to hear your comments. And if you have any questions, reach out to me publicly or privately. Otherwise, enjoy the journey, leverage AI, let it do the heavy lifting. And between now and the next episode, enjoy the journey and never stop making each day your masterpiece.